Afternoon, everybody. My name is David Cole. I am the chair of this afternoon's panel. Probably because most of you don't know who I am, I should tell you a little bit about why I'm here. I am a provincial court judge in Toronto and have been for the past 30 years. Before that, I was a prison litigator, and I have a history going back to the early 1970s of dealing with, particularly at the federal level, CSC's diligent, and I have to say diligent, efforts to avoid any responsibility, to have any accountability at all in relation to what was then called administrative segregation. In point of fact, Howard Sapers, who was for many years the correctional investigator, probably doesn't know this piece of history, but his first predecessor, Inger Hansen, set up an inquiry under the Part 3 of the Inquiries Act to investigate the use of tear gassing and force on several prisoners in Millhaven Institution in 1974. Together with Paul Copeland and Alan Manson, I represented those prisoners, and her inquiry, which is public, although not very well known, was one which attracted at that time quite a lot of attention and very much helped to focus some of the issues that had been originally developed in Michael Jackson's excellent book, Prisoners of Isolation. The second reason I'm here is because I was, as a prison litigator, I took one of the first cases to the Supreme Court of Canada on prisoners' rights. And although, as usual, I lost 9-0 in the Supreme Court of Canada, in the case of Solitary versus the Queen, the court made a very important statement about prisoners. I wish I could grasp some ownership of what the court said, but I didn't. They came up with it themselves. Justice Dixon, writing for the court, made the very important statement that a prisoner retains all rights except those which are necessarily incidental to incarceration. And that's a very important statement, and one which I don't think has been focused enough in people's minds, and certainly in court proceedings since that time. And it might be a good idea for those of you who seek to litigate these issues always to throw that quote in, because it's an important one about retaining all rights, which brings in the principles of restraint when those kinds of things are taken away. The final reason I'm here, which I will get to after our other speakers have given their presentations, is that I was seconded from the bench for 2 years to monitor the response of the Ontario Ministry of Correctional Services to a human rights application brought by a woman called Ms. Jan. And Mr. Sapers is going to talk to you about that. And then I will have a few comments about the progress of what happened to the Jan inquiry and the provincial government's response. So our first speaker this afternoon is Mary Campbell, who in the space of 15 minutes is going to give us a history of segregation from the Middle Ages to the 20th century. Good luck with that, Mary.
Can you hear me? Good. Yeah, we're going to do a very quick tour of history because I really do believe strongly that unless you know where you've been, you're not going to know where you're going. And I think that understanding the origins of solitary confinement and how it operates and why it operates really has to be set in the context of our perceptions of and attitudes towards criminal justice. I think that the tentacles of solitary really are pervasive and deep in our approach to criminal justice. Had we chosen a different path, I don't think we'd necessarily be having this discussion about solitary confinement. Yes, there's a lot of history that's been written, and certainly, as David mentioned, Michael Jackson's seminal book, Prisoners of Isolation, there's quite a good summary at the beginning of that book that I recommend to you. I would note that it was published 37 years ago, for those of you who think that we're having a fresh discussion. I think that the Western world always had this approach in criminal justice of responding to people who are different by separating them, by pushing them away, abusing them, and segregating them, as opposed to embracing them and healing them, if I can use that kind of approach. Looking even to the Middle Ages, and I won't go back further than that, you'll be happy. Obviously, capital punishment was the most extreme form of separation. You can't get much more separated than that punishment. It was widely used in the 1700s in Great Britain, where our system comes from. Indeed, the Bloody Code by late 1700s had over 200 offenses that carried the death penalty. Over 200 offenses that carried the death penalty. There came a point, though, where some juries were unwilling to convict because of the harshness of that punishment for relatively minor crimes. The other punishment was another separation, if you like, which was transportation. Put the prisoners on a boat, point it towards the Atlantic Ocean, and give them a shove. That was as well fairly popular. But in addition to juries shying away from capital punishment, transportation was not as viable after the American Revolution in 1776. There was always Australia, but that was a much longer journey. Around the same time then, when you have two of these punishments falling into disfavor, there was similar thinking about the corporal punishments, things like branding a thief with a T on the forehead that can slow you down going into Shoppers Drug Mart, I think, throwing a hard cabbage at someone in the pillories, which is, satisfying maybe to the thrower, but a waste of a cabbage. And there was a sense that these punishments were not only cruel, but ineffective. And the social emphasis started shifting towards more of a reform focus. And so where do you turn at that point? Well, you turn to this thing called imprisonment, which was in use, but really only for pretrial detention. There's a great quote from that time period. An official was saying, "What do you mean imprison them as a punishment? Good Lord, that's just a waste of money. It's very expensive." But it became popular both as a way of separating people and potentially a way of transforming the soul of the offender. And so you had people like John Howard and Jeremy Bentham with slightly different philosophies, but both of them seeing imprisonment as a viable option to separate people. There was recognition that it was brutal to imprison people, but also humane, they felt, because it didn't involve any corporal punishment per se, and because it facilitated that personal reflection and moral reform. Ignatieff had a great way of phrasing it. He said, imprisonment reconciled terror and humanity. So there were two systems that came into being for imprisonment, because you think about, well, how are we going to imprison them? What's the model going to be? They were both founded on the idea of solitude, or slightly differently. The separate system, inmates lived and worked entirely separately, entirely alone in their cell. And of course, there was no talking allowed. So this was pure 24/7 solitary confinement. It was perceived as having two benefits: maximum time for self-reflection. Yeah, you got to believe that. And secondly, it ensured that the inmates did not collaborate or get into fights or stir up trouble. Eastern State Penitentiary in Philadelphia is still a remaining example of The separate system opened in 1829. And once people travel again, I highly recommend that you visit Eastern State Penitentiary. You'll see there that some of the cells are larger than normal because, of course, the person had to work in the cell as well. So if you had your spinning wheel or what have you, you needed that space. But the negative impact of that kind of isolation, going on not just for months, but for years, was not difficult to see. And the self-reflection and the moral reform or redemption was clearly not materializing as had been hoped. There was a visit by Charles Dickens, of course, in 1842, who wrote a scathing condemnation of this. And really, I'll just quickly read it because I think it does capture history, and some might say today. In its intention, I am well convinced that it, solitary, is kind, humane, and meant for reformation, but I am persuaded that those who devised this system of prison discipline and those benevolent gentlemen who carry it into execution do not know what it is they are doing. I believe that very few men are capable of estimating the immense amount of torture and agony which this dreadful punishment, prolonged for years, inflicts upon the sufferers. And in guessing at it myself and in reasoning from what I have seen written upon their faces and what to my certain knowledge they feel within, I am only the more convinced that there is a depth of terrible endurance in it, which none but the sufferers themselves can fathom, and which no man has a right to inflict on his fellow creatures. That was in 1842. He actually concluded that it would have been better to have simply hanged the offender rather than place them in that kind of solitary confinement. When Eastern State Pen and other separate models started to move away from that intense isolation, it really, though, wasn't so much the cruelty of it that motivated them. It was actually the financial burden. First of all, of course, if the inmates are all in their cells, then they're not able to do the work of the penitentiary, cleaning and cooking and whatnot. So you have to hire people to do that. And secondly, of course, individual projects in your cell are not going to make as much money for the penitentiary as big projects done jointly. The other system was the silent system, operated in tandem. Modified solitary confinement, they were allowed out during the day to work communally, and that was Auburn was the main one that did that. Sing Sing also had that model, NKP, when it opened. But it was very much almost a virtual solitary confinement, because even when you were allowed out of your cell to work, you were not allowed to speak at all. And in fact, the regulations actually said, must not exchange a word with one another under any pretense whatsoever, nor communicate with one another, nor with anyone else by writing. They must not exchange looks, winks, laugh, nod, or gesticulate to each other. So a virtual separation. And the thinking of the day was really that both discipline and moral reformation could not be achieved without solitary confinement to some degree. It was essential. I mean, it was just a given. And indeed, Kingston Pen and all the penitentiaries built in Canada thereafter, there were 7 by the early part of the 1900s, all of them contained segregation cells for disciplinary or administrative seg. You know, when you move up to the Archambault report in 1938, as revolutionary as it was, and promoting a different approach to corrections, it still accepted without question the need for solitary confinement. At one point, they say the object of these seg regulations is to remove from the penitentiary population prisoners who may be agitators or of an incorrigible type and a disturbing element to the maintenance of discipline in the institution. We quite recognize the necessity of these regulations. Archambault did, to their credit, recommend some procedural protections. So the rules were you could be in segregation for a max of 1 month. If the warden wanted more than that, they had to go to a higher authority. And Archambault argued that should be only in the most unusual cases. There must be strict compliance with the rule of law. Where have you heard all this before? A great care should be taken to prevent injustice. through the imposition of SEG. Following Archambault, as all you good students of corrections know, I mean, there was just, when I sat down to go through the reports again, I mean, it's just astonishing the quantity of reports from the 1900s and the litigation and the studies that called for an overhaul in how we approach corrections, and in particular then how segregation was used, called for restraint in its use and greater procedural protections. So, you know, you can look at Fautou in 1956, and most people think of that report in terms of the creation of the parole board, but they had a lot to say in that report about correctional operations. Vantour, some of you will remember Jim Vantour. He did a report on dissociation in 1975, very critical. In fact, I thought of Tony Dube and Jane Sprott because the first line in the report is that the committee was appalled by the data that was available to them. McGuigan in 77, prisoners of isolation in 83, and all the associated litigation, correctional law review, 1987, Working Paper 5, the Robert Gentles inquest. Some of us remember Robert Gentles. Arbour, the Yalden Working Group, the CBA's reports and other NGOs, OCI reports, the Ashley Smith inquest. I mean, the list is staggering of studies in the last 100 years in particular, but the last 200 years that have looked at segregation and made recommendations. And yet, here we are 200 years later. I hate to say that we're having the same discussion, but frankly, we are. And I think one of the things that Howard will talk about is the Ontario Draft Act that almost made it, because I think fundamentally you can't change SEG or improve SEG unless you tackle the context of it. And that was one thing that was attempted in that bill, was to obviously alter the correctional context and philosophy. And only then do you start to look at SEG. Otherwise, I think, you know, we run the risk of just talking away. If I read to you that Charles Dickens quote, just cold, would you have said, oh yeah, that was 178 years ago? No, you probably would have said that observation was, you know, from this century. There is, I mean, with all due respect to the great Yogi Berra, there is actually, and see if I was technical, I would play it for you now, a John Fogerty song from 2004 that is called Deja Vu All Over Again. And I fear that what we've had is 200 years of legislative reform, serious thinking, serious writing, and yet here we are in the same conversation. Call them SIUs, call them a partridge in a pear tree. I really wonder if we're any closer to reforming SEG, and certainly not without some kind of fundamental rethinking of imprisonment itself. That's the fastest 200 years that I think I can do.
Thank you, Mary. Just before I go on, first of all, an announcement. At the bottom of your screen, you will find a button called Q&A. If you have questions and answers, or questions that you wish to pose to any of the panelists, please put your questions in, and we will try to get to them when the speakers are concluded. Just before turning it over to Howard, I would like to draw to your attention one of the most horrid things that I can recall about Kingston's silent system. If you go back to the Kingston Penitentiary silent system, if you go back to some of the punishment books of the 1840s, children as young as 7 were lashed for laughing. Perhaps we've made a little progress since then. Our next speaker is Howard Sapers, who will talk to you about reforming Ontario corrections. Howard?
All right, let me make this work if I can. There. I hope everybody is seeing the slideshow. Thank you, David, and thank you, Catherine, for organizing this. I am speaking to you today from my home in Ottawa, which is on the traditional territory of the Anishinaabe Algonquin people. And I am very grateful for the opportunity to live and work in this territory. Mary has given us a great foundation to have this conversation. And I share her refrain that this is there's very little new in about what we're going to talk about. That said, there's still the opportunity, of course, to change the narrative, and I do feel that this conversation has been changing over the last decade, and just the fact that we're having this series speaks to that. Mary talked a little bit about Eastern State Penitentiary. I actually told Mary that I was going to cut this slide out of my deck, but I'm glad I didn't, because for those of you who are having trouble visualizing what Mary was talking about, this is the epitome of the separate system, with this spoken hub model, with the segregation, the individual cells radiating out from a central hub. So not only was there no interaction really between those who were being held in custody, but also the keepers. They stayed in the hub and pretty much controlled things from there. This design was exported all over the world. It was considered a sociological and a technological marvel. One of the innovations in Eastern State Penitentiary was actually that they had plumbing in the cells, which actually had, so it had wet cells, flush toilets, before the White House did. I won't dwell on Eastern State Penitentiary, but just to know that this design is still evident in modern practice, and you can just go around the world and you can still see this kind of hub and spoke model. Solitary confinement, segregation, isolation has been a feature of corrections for far too long, and continues to be a feature in almost every custodial correctional system. And what we know is that even if you try to humanize it, the circumstances are still extreme limitations on movement and association that really have nothing to do with preparing people for release after their period of incarceration. All of this is governed by international laws and standards. I don't want to go through all this. I know there's other sessions during this series that are going to talk a little bit more about the norms and laws and a little bit about the litigation. But just to say, and really this just underscores another point that Mary made. This is not without structure. This is not without attention. This is not without some oversight and some guidance. And in spite of that, it continues to be part of this conversation about the worst of what goes on in institutional corrections. You know, and Canada does not have a happy history. And in spite of our charter, in spite of the 1992 Corrections and Conditional Release Act, in spite of provincial and territorial human rights legislation, we continue to see abuses. And I hope David will mention a little bit more about Christina John, because I'm not really going to spend a lot of time talking about Christina, other than to say that Christina John is a young woman who was held in custody at the Ottawa Carleton Detention Centre over two periods of time, very close together. Christina had the misfortune of suffering from chronic mental health issue, and also an acute physical health issue. And she finally took her complaint to the Ontario Human Rights Commission, and the commission has launched a long-standing series of complaints regarding the fact that the Ontario Corrections has not fully lived up to the public interest settlements that were agreed to after Christina John's complaints had been adjudicated. And David has had a big role to play in the oversight of that, and I hope he'll speak more about it. So, in spite of the fact that we have this body of international law, this history, as Mary said, of 200 years of knowing better and trying to do better, and we have our own domestic legislation, it continues to be the subject of this debate, litigation, academic study, and often outrage. And outrage is probably the best word that I can use if I can draw your minds back to 2016, and then this from the spring through the summer into the fall of 2016. This is just a sample of some of the headlines that we were faced with here in Ontario. And I do want to draw your attention to the bottom left-hand corner, a story about Mr. Capet, Adam Capet, a young man who's being held in the Thunder Bay jail in pretrial custody. While he was in pretrial detention, he committed another crime, a serious violent crime for which he was charged. And he subsequently spent over 1,500 days, continuous days, in a segregation cell that was relatively isolated from not only the other prisoners, but within the institution itself. It wasn't even in the typical or the normal segregation range. Mr. Capet's cell was never quite in darkness, even though there was no natural light, no windows. A light was always on. His cell had been lined with plexiglass to ensure that he couldn't throw things through the bars. He was visited in those conditions of confinement by the then Chief Commissioner of the Ontario Human Rights Commission, and that set off another firestorm. And that firestorm, but this is the cell that Mr. Capet was actually in, and these are the conditions, his living conditions for those 3 years that he was held in solitary. This came to the attention of the Ontario legislature, the Premier herself, and the Premier made a very public statement. This is extremely disturbing. It should not have happened. It's unacceptable. The status quo is unacceptable. This degree of political attention is very important for our conversation. Change in corrections is often crisis-driven, and many people have said this before, never waste a good crisis. Certainly the Premier of Ontario didn't want to waste a good crisis, and so they decided they were going to try something a little bit different. That different thing, sadly, turned out to be appointing me to do a review, first of segregation in Ontario, and then of broader issues. One of the things that I said to the Premier when I was first approached to do this work is that just looking at segregation isn't enough. Segregation happens in a context, and that context is often other dysfunction within your correction system. If you're overusing segregation, and if you're putting people into these segregated cells for reasons other than immediate safety or security issues. In any case, Ontario asked me to look at several things. They wanted to reduce the number of people held in seg. They wanted to build a system of alternatives to segregation placement. They wanted to make sure that segregation was rare, that the conditions of confinement would be improved for those who were segregated. They wanted to enhance oversight, improve the training and recruitment process for staff that would be more values driven. And they wanted updated legislation, regulation, and policies and procedures. So that's a pretty big menu of things. And then they asked for that report to be completed in 60 days. I had a very small team who were incredibly talented, but in spite of their talents, their considerable wisdom and talents and effort, it took us 72 days actually to write the report. Let me tell you a little bit about what we found. In Ontario, there's a steady state at that time. There were, let's say, 8,000 men and women in Ontario jails, 25 jails across the province. And there's a churn of about 60,000 people, and anywhere between 60 and 70% of those people are in pretrial custody. With that, there were over 2,500 distinct admissions to segregation in the year that we had data for. And over 1,000 people who were segregated had spent more than 30 continuous days. Now, remember, the special rapporteur from the United Nations had said that 15 days, anything exceeding 15 days, could be considered cruel and unusual punishment when it comes to the use of segregation. Sadly, over 1,300 had spent more than 60 days, even though the average length of time was only 12. So that means that we had a group, an elite group of men and women who the system had basically given up on and had said, we have no alternative but to hold you in continuous segregation. And in spite of the outrage around Mr. Capet, we found a number, and depending on who was counting, anywhere between 10 and 13, who had been continuously segregated in provincial custody for years. And almost all of them were pretrial. Those who were segregated were overwhelmingly at risk. They had suicide risks and alerts noted on their files. They had known as significant and diagnosed mental health issues noted on their files. When you look at this table or this chart, Mary made a reference to the poor data that James Van Tour had mentioned, and that Tony Duke and James Brott will talk about when they talk about SIUs. When you look at this particular image, what you see is that it looks like in 2 months, there was very little segregation. In fact, that's not true. What there was very little data. So even in a situation where there's lots of effort made to count and lots of effort made to ensure that there's oversight, if people don't collect or input the information, it's just not there. And if you can't analyze it, you can't learn from it, and you can't learn from it, you can't change things. And this is very much what I found in Ontario, is that the numbers weren't always very good. In spite of that, we were able to reach some conclusions. Those conclusions is that where that segregation was being overused for Indigenous men and women, it was being overused for people with mental health issues. And it was particularly bad when there was an intersection between those two, that population, when it came to Indigenous women. So we produced our report. The government of the day actually was grateful for the report and made a commitment to take action on all the recommendations. And there was work actually commenced. One of the things that started almost immediately was beginning to do work on a new legislative draft. And this is the first time I think I'm going to out the role that Mary played in that. Mary very graciously agreed to support the work of the independent review by giving us the first a broad draft of what could become model legislation. And I think it's important that we have that model. And even though I'm going to tell you some bad news about what happened to it, coming out of the report, we identified themes, and we wanted to reflect all those themes in new legislation. themes about law and policy, about the definition of segregation, about the inappropriate use of segregation, the particular concerns around the intersection of mental health and isolation, the segregation review and accountability process, more direction on the types of data and undertakings to ensure that proper data was collected, training and deployment issues. And then outside of the legislation, of course, we wanted to look at infrastructure issues. In total, we made 41 recommendations. That led to the Ontario Correctional Services Transformation Act, which actually received royal assent on May 3rd, 2018. The act dealt with many important issues. It set rules for clearly defining segregation as conditions of confinement instead of a status within the institution or a set place within the institution. It improved conditions for those who were going to be segregated. It increased transparency and accountability and oversight. Ensured incarcerated individuals would have improved access to health care, particularly mental health care and screening. And all in all, the act was principles-based, values-driven, and really for the first time was clearly focusing in legislation Ontario's custodial corrections system on reintegration into the community with a rehabilitative framework. So the good news is that this legislation was drafted relatively quickly. It received support in the provincial legislature. There were a few issues raised during debate, but really nothing terribly substantial, and it got royal assent, as I say, in May. Then we had an election, and the act was not proclaimed before the election, and the act has never been proclaimed. And so the old act, which was found to be deficient in almost every regard, is still the governing legislation in Ontario, even though Ontario has this very progressive model legislation that's been given royal assent. And I think that's a shame. So things like having a new inspector general, which could continue to shed light on abuses regarding conditions of confinement or the overuse of segregation, simply don't exist in law in Ontario, even though that was the intent of the provincial legislature in the spring of 2018. All is not lost, however. I want to give a shout out to Yukon. About almost 2 years ago, Yukon made a commitment to make some changes in the corrections system, and it was more than 2 years ago actually, and based on a special report that was done on a very sad situation involving the continuous use of segregation in the correctional center in Yukon. The commitment was made to change things. In the fall of 2019, the Yukon Legislative Assembly passed Bill 38, which made amendments to their Corrections Act. And what we see are some of the similar features of the Ontario bill. Segregation is now defined by conditions of confinement, not as a housing unit. It prohibits segregation of defined populations, such as pregnant inmates or those with the diagnosed mental illness. Caps continuous segregation 15 days and cumulative segregation 65 days within a 1 year period. And there are independent adjudicators appointed for decision-making around segregation. And the whole thing is based on some of those international laws and standards I mentioned at the beginning of my remarks. And that is, it reflects and reinforces some of the principles in the Mandela rules. So while I generally agree with Mary and almost never question Mary, I will say that things have changed just a little bit. And if you can stomach slow, incremental change, then I guess that's what we're faced with. Thank you very much for inviting me to participate in today's discussion, and I hope we have some time for questions.
Thank you, Howard. I'm always a little reluctant and hesitant whenever I get to introduce Kim Pate, which I do about once every 2 years. It was relatively simple when she was just Kim Pate, Executive Director of the Elizabeth Fry Society of Canada. That was relatively easy. Then I had to remember when they started giving her honorary degrees, I had to start referring to her as Dr. Kim Pate. That was okay. Then it became Senator Kim Pate, which it is today. Unless something's happened in the last sort of 24 hours, I can still call it her senator, but I worry that the next time I may interview her, she may have another title, perhaps the first woman pope. Kim.
Thank you, David, for that's very funny. I want to thank you very much, David, for that introduction. I will always be Kim Pate, I hope, for forever and until I die. But at this stage, I wanted to start, and as Howard did, by acknowledging that I'm joining you from the unceded, unsurrendered territory of the Algonquin Anishinaabe, otherwise known to most people as Ottawa. And I want to also thank Mary and Howard for leading us through some history. And also David, of course, for the way that you are shepherding us through, and Will with the questions and answers. And I also want to thank Adelina Iftene, who has agreed, because those of you who know me know I'm also an incredible techno-twit. And I tried to figure out how to share my screen and do all of that and couldn't. So there's a slideshow that will actually play along as I'm talking. And my main reason in providing this is in addition to the images that I want you to see, I want you to think about how you could be using some of these images, because these are images that we are starting to create as we visit prisons. When I say we, groups of senators, about 30 of us have been going to prisons. We've had to stop because of we've had a hiatus. We haven't had to stop, but we did stop because of the pandemic, but we'll be continuing on again as soon as it's safe to do so, recognizing that many of us are among those of the age and certainly health issues that make it a risk for us to both be super spreaders because of travel and that sort of thing, but also to potentially succumb to it. So I want to thank you very much for this. My interest in segregation, not surprisingly, started when I was working with young people, and then with men, and then for the 25 years that I was with Elizabeth Fry Societies. I was interested when I first looked at the legislation under the Young Offenders Act, as well as under now the YCJA, and also with the work that was done on the Task Force on Federally Sentenced Women, which was tabled in 1990, just 18 months before I joined E-Fry, that in fact for both youth and women, long before we had the UN guidelines that would govern segregation, or that would try to put caps or put, I would say, a floor, not a ceiling on segregation. But within Canada, we were already exploring the idea of getting rid of segregation entirely for those groups. Then as we moved ahead, we saw increasingly focusing on other groups, whether it's Indigenous peoples, people with mental health issues and disabling mental health issues in particular, people with brain injuries. And we started to see more and more focus on the need not only for oversight, but as Louise Arbour first really articulated in her report following the events at the Prison for Women in Kingston, the need in 1996 in her report, she called for the need for judicial oversight, recognizing that many of us, although the independent oversight models that have been put in place for things like severe or serious charges, that sort of thing, were models that we thought might be of use. But basically as recently as just the last week, with the reports coming from Dr. Dube and Dr. Sprott and the Tony Dube and James Spratt, we know that in fact those independent models are are very much reliant on the very bodies that both record and interpret their own data. And so, recognizing that, and recognizing, as she's often quoted as saying, the fact that although the rules were everywhere and are everywhere within correctional settings, the rule of law is virtually absent. And I would say, despite all of the changes, and I agree very much with obviously what Mary's presented, as well as Howard, that there have been some, and what David said, there have been incremental steps. We are in a moment where we are seeing, in fact, the opportunity to do something very different, and yet the reluctance seemingly of everybody, from the very lawyers representing individuals, the courts that hear some of those cases, as well as obviously the correctional authorities responsible for the systems, to move ahead. We've seen some notable exceptions with, and here you see on the screen, Renu Mandani, who was chair of the Ontario Human Rights Commission when they took a position against the use of segregation for women, for youth, and those with mental health issues. But we've seen both the Ontario Human Rights Commission and the Canadian Human Rights Commission take those positions. We've seen the development of UN minimum standard rules that didn't exist before around some of these sorts of areas. But it's really vitally important, having done that work on the development in particular of the Mandela rules and the Bangkok rules internationally, to recognize those really should be seen as floors, not ceilings, particularly when we come to Canada, where we have a charter, where we have the kinds of human rights bodies, where we have the kinds of international reputation of being human rights, not just defenders, but promoters. And so those standards and the 15-day limit that were put in place as part of the negotiations when you look at a whole array of countries that have a whole array of protections, or more importantly, lack thereof. And so the fact that it's considered torture internationally does not mean, in my humble opinion, that we should be looking at something just slightly less than that as somehow fitting within our charter protected grounds. And so, as many of you will know, and a number of us were pushing, and certainly before I was in the Senate, we had human rights complaints in 2003, following up on the Arbor recommendations, as well as in 2010. And interestingly enough, Christina John wanted to join our federal human rights claim, and went to the Ontario Human Rights Commission because she had been a provincial prisoner, not a federal prisoner. And like the federal prisoners we were working with, wanted to see an end to the use of segregation, not the kind of mediated version that ended up being recognized as part of her name. And until she died, that was still a regret that she had. And part of that was the challenge of actually getting counsel and those who are advocating in this area to take the positions that, ironically, almost 2 years ago now, a year and a half ago, senators took. 30 senators defended it even after the government did it, but the entire Senate passed changes that would have fundamentally shifted how segregation could operate by whatever name it was known in this country. And some of you will be aware that the amendments that the Senate made to Bill C-83 that weren't picked up weren't just about segregation, but they were all about ensuring that segregation was used less, and that in recognition that corrections having litigation brought against it by two bodies, and having BC Court of Appeal and Ontario Court of Appeal rule about it, fundamentally shifted its policy and allowed them to believe that they must change their policy. And that alone caused them to cut in half and even further the number of people they were actually segregating in segregation units. Now, it also meant they continued a process which had started some years before in terms of increasingly separate units, and having more and more people held not just in a general population, which those of you who know the corrections legislation pre-C-83, you were either in general population or you were in segregation. That was essentially the law. And many of us were challenging the fact that in maximum security institutions, in mental health units. Increasingly, groups of people were being kept in conditions of isolation that amounted to segregation, if not solitary confinement, certainly not general population. And so some of you will be aware, and you saw one of the slides showed that some of the alternatives that the Parliamentary Budget Officer costed when we were looking at Bill C-83 included the notion, the idea of completely desegregating women's corrections, for instance, the recommendation of looking at models that would address the issues that were still and are still being used to justify segregation. So what are the arguments usually used? Protection or gang affiliation, and in particular because of gang affiliation. So we went to Rick Sauvé, who some of you heard as well speak in this series, and talk about the incredible work he's done getting people out of segregation. So we talked about the costing of that. The other thing we did is talk to people in segregation and to a person, and this parallels what Don Davies, who's one of the few MPs that I know who has gone into segregation units, also found, is despite the rhetoric that people wanted to be in solitary confinement, if you just ask the next question, why? Most people want to be there because they feel they need to be protected or because they want quiet time. And both of those are not valid reasons, in my humble opinion, for us to be segregating people. So when the Senate looked at this, we looked at also strengthening the principles section to have least restrictive measures that Mary was instrumental in ensuring was in the first iteration of the Corrections and Conditional Release Act. We also looked to strengthen the provisions that would provide off-ramps out of the prison systems, Section 29, particularly for health and mental health reasons, and also Sections 81 and 84, and to require that, in fact, the types of approaches that are provided by Section 718(2)(e) of the Criminal Code are used to also provide ways to get folks out. So I encourage all of you who are doing this work that we need bold approaches now. We don't need to continue to look at the types of approaches that merely look at precedents and what courts have accepted to date. I think we should be looking at, and I commend a number of you who are reaching out and are using the Senate amendments as guiding factors. We know from that if in fact corrections is justified in having to separate people, then they should be able to make that case. They should, and even if judges don't stop the use of segregation by using judicial oversight, we know very well that that will actually put the evidence before the courts in the way that Tony Doob and the Ministerial Advisory Committee and the independent decision makers are articulating they have not been able to do. So even though we've been assured by Bill C-83 that independent decision makers have a decision-making authority and can change decisions, those of you working in and around the system know full well that hasn't occurred, that in fact their decisions have not been followed. And so we need to be looking at some of those measures. And what are some of the things we could be doing? Well, in my opinion, I think we could be using the reports that have come out so far, all of the ones that, as well as some of the presentations that you've heard today, to argue that we, to bring habeas corpus, certainly group habeas corpus, I would argue as well, civil actions, particularly tort actions, as well as and other kinds of claims involving negligence on the part of corrections to follow through on its obligations, its legal obligations. I think we could also be looking at the kinds of civil suits that have been brought around mental health issues. And we should be arguing that no matter what the name is, we should be looking at the conditions of isolation as opposed to what the name is. And so one of the challenges, of course, with the structured intervention units is the law only applies to those. It doesn't apply to the step-down units, the voluntary limited association ranges, the medical observation units, the quiet time cells, or any of the other type structured movement that is being put in place that are actually euphemisms for segregation or solitary confinement. And I think the other area we could be looking at started my foray into the international fora that led to being involved in the Mandela and the Bangkok rules development was the optional protocol on the Convention Against Torture. It is one way to provide the kind of oversight that Howard has and others have tried to ensure was in the Ontario legislation and the Yukon legislation. But even the Ontario and the Yukon legislation are not being adhered to. Well, obviously, Ontario hasn't even been implemented. But the first iteration of the Ontario legislation actually called for at least 4 prisons that would not have segregation units of any sort. And so we need to be pushing, I think, for those bold approaches and for the approaches that will actually lead to the decriminalizing, decarcerating, and certainly the desegregating of individuals. And so I look forward to working with all of you and thank those of you who are using some of those mechanisms to take the much bolder step of really calling for the elimination of a practice that I suspect in 10 years we will think should have been called barbaric long before it ever ends up being. Thank you very much.
Thank you, Kim. As they say in my sometimes, faith from your lips to God's ear. Let me talk to you about Ms. Jan a little more, because this is, I think, significant, particularly when looking at provincial segregation. Ms. Jan was, as Howard said, she was a woman with mental health and physical health challenges who was incarcerated on 2 occasions at the Ottawa Carleton Detention Center. And on both occasions, the authorities took one look at her and said, "You're going directly into segregation." When she got out, she went to counsel and she began litigation, and counsel had the good sense to join as a party the Ontario Human Rights Commission, because she alleged that, Ms. Jan alleged that her human rights had been interfered with. And this enabled the Human Rights Commission to get involved in this area. Ms. Jan received a financial settlement that is private to her and the ministry, and I will not go into further, but once she had received her financial compensation, and she was reasonably assured that the Human Rights Commission would continue to press her interests, the matter devolved to the Human Rights Commission, which after some time entered into a settlement with the Ontario Ministry of Correctional Services, as it was then called. The ministry undertook to conduct a number of what were called public interest remedies. I'm not going to go into them, but the history of it was that after a couple of years, the ministry had not really done very much, claiming that, well, you know, it's a big ship, it's difficult to turn around. There are 25 institutions in this province, varying in size from 25 prisoners to 1,650. It just takes time. So the ministry and the Human Rights Commission then entered into a second settlement, and actually a third one, but I'll leave it as a second big settlement. And what I was asked to do was to monitor the ministry's compliance with approximately 31 undertakings that it had made to the Human Rights Commission. I was called the independent reviewer of the ministry's progress. I had with me Professor Kelly Hannah Moffat and a team of criminologists who were called the independent expert, and their job was to collect data which would assist me in evaluating whether or not the ministry had complied or was complying with its undertakings. I think what's important to keep in mind is that if you want to have any success with anything, you must get the political folks on your side. 25 years ago, I co-chaired the Commission on Systemic Racism in the Ontario criminal justice system. And one of our areas of interest was provincial corrections. We wanted to investigate whether complaints of racial bias and racially different treatment in provincial corrections were justified. Luckily, the then Minister of Correctional Services invited myself and my co-chair to a meeting where he hauled in all of the deputies and assistant deputy ministers and said, you will cooperate fully with these folks. There will be no holdbacks. And although inevitably there are glitches along the way, or there were glitches along the way, by and large, that direction from the minister down to the deputies and assistant deputies was very important to the success that we had in getting some data. Unfortunately, in this Jan settlement, none of the three ministers, the previous Liberal minister, Ms. Lafrance, who Howard referred to, nor the two ministers of the current government have expressed any interest in meeting with myself and Professor Hannah Moffat at all. Secondly, absent their kind of direction to the senior bureaucrats, we had, and I don't mind saying this, we had a deputy minister, and I know Mr. Sapers can back me up on this, a deputy minister who simply was not interested in these issues and did not instruct his assistant deputy ministers to be of any particular assistance to us. And that showed up because throughout Professor Hannah Moffat's efforts to get the data that she needed from the ministry, there's little doubt that there was a deliberate, or if not deliberate, certainly pretty close to deliberate policy of non-cooperation. Data was not given, it was given improperly, it was given incompletely. When Professor Hannah Moffat and her team asked questions about, well, why can't you give me the original so I can look at the documents? They said, well, you know, et cetera, we have to get authority. And it took months and months and months for her to begin to get any kind of data which she could analyze properly. Similarly, when I asked for various background data that I knew existed, I was told that it did not exist. When in fact it did, and it wasn't until about a week before my final report came out when I threatened to expose the ministry's lack of cooperation that amazingly the data that I'd been asking for 18 months turned up. So I think the first lesson to be learned is if you're doing any kind of inquiry, you need to, as best as possible, get senior officialdom and the senior political figures involved, because absent that, you're going to be frustrated. Secondly, and my report was pre-COVID, and the timing of the delivery of my final report in February of 2020 couldn't have been worse, because that was immediately before COVID. But there are significant differences between provincial and federal segregation. The first one is that you must keep in mind that about 70%, it's higher in Ontario and Alberta than anywhere else in the country, but it's around 70% of prisoners are remand prisoners. So one of the questions that arises, particularly in relation to the mentally ill, is why, if they're going to wind up in segregation anyway, why are they in custody? Why can't we make better efforts to get them bail? Because A, there's this thing called the presumption of innocence, which the Supreme Court has strongly reminded us of in recent years. And B, if they're going to be in segregation, if correctional authorities, for good reasons or bad, are going to put them in segregation in any event, why don't we just make better efforts to get them out? Now, the response of Ontario's correctional ministry, which I suspect is probably typical of of other correctional ministries across the country is to say, well, that's not our responsibility. Bail is the responsibility of the Ministry of the Attorney General. Only in Alberta that I've been able to find, and occasionally ad hoc arrangements in other parts of the country, as between, say, a superintendent of a provincial institution and his local Crown attorney, has any effort been made to try very hard to link bail to pretrial incarceration. There are some excellent models in Alberta. There are quite good models involving the John Howard and Elizabeth Fry societies in Ontario. Those models need to be looked at, but most important, the provincial correctional ministries and the ministries of the Attorney General and the local legal aid plans must work together much better than they do. Interestingly, I made a number of recommendations on this. Interestingly, what seems to have happened is that COVID has promoted the Ontario Ministry of Correctional Services and the Ontario Ministry of the Attorney General to work much more closely together. Ontario seems to have, and I'm not sure about how good this data is, it seems to have reduced its correctional population by about 25%, the vast majority of whom are remand individuals. The second point I'd make to you is that you need to have a good understanding of, at the provincial level, of what oversight mechanisms exist. At the federal level, we actually have fairly good oversight mechanisms. We have the Office of the Correctional Investigator with their various powers. We have a number of powers by which witnesses are brought before courts and are forced to justify the maintenance of what they're doing, of which the Capet case in Ontario is an outstanding example, where a murder charge was stayed, but largely because of the way Mr. Capet was treated. However, Ontario, rather, I suspect, like other provinces, has absolutely no oversight, external oversight at all. There are no province-wide committees charged with inquiring into corrections. The last one that I know of died off in the 1980s and was never replaced. And although people like the Human Rights Commission, the Ombudsman, even the auditor will from time to time have things to say about the administration of corrections provincially, they will be the first to tell you that their job is not to, in any sustained way, hold the ministry's feet to the fire. The current legislation, or the legislation that Howard showed you that was actually written by Mary, and she didn't do a bad job on it, could have been a little better, but we'll see. The legislation has provided for external scrutiny of administrative segregation and external scrutiny of disciplinary segregation. The current government has refused to do anything with that legislation. And furthermore, one of the things that continually frustrated Professor Hannah Moffat and myself was everything got defined as a draft. Draft policies on definitions of mental illness, draft policies on the way segregation is to be set up, draft policies on the way prisoners are to be categorized and placed. Never anything final. So that the ministry could always say, yes, these policies are being discussed, but they have not yet been implemented and therefore they are not binding. This is very frustrating, and I'm going to suggest to you that perhaps publicity is one of the best ways to deal with it. More specifically, in relation to external scrutiny of administrative segregation, Ontario has taken a particularly conservative view. they have taken, for those of you who are lawyers, they have taken the view that what is said by Justice Morocco in the Ontario Canadian Civil Liberties Association case, for you lawyers, it's paragraphs 172 to 176. They have taken the position that this is the guiding law in Ontario, and that whatever the British Columbia Court of Appeal may have decided about the constitutionality of that structure is not their business. So thus, and this is actually in the draft policy that they have for, that Ontario currently has for the rules to guide administrative segregation. I'm quoting from Justice Morocco. The administrative review of a decision can be independent and impartial if the reviewer is not chosen by the person whose decision is being reviewed, not reporting to the person whose decision is being reviewed, completely outside the circle of influence of the person whose decision is being reviewed, and given the need for a prompt decision, able to substitute its decision for that of the person whose decision is being reviewed. Ontario has interpreted that as meaning that reviews are to be restricted to internal decision-making processes within the ministry. Yes, they bumped it up a bit in the sense that after initial decisions are made within a few days, the matter must go up to the Assistant Deputy Minister in charge of institutional services. But Ontario does not contemplate having any external review whatsoever by any genuinely independent person. Another point I'd like to make to you based on 45 years of litigation is that when I used to litigate a lot of these issues, and people like John Conroy and Alan Manson and to some extent Michael Jackson and a few others across the country, when we used to litigate these issues, our general relations, particularly with the Federal Department of Justice, were usually excellent. In fact, as between from lawyer to lawyer, what we would often do is we would notify the feds that an action was coming and send them draft material so that they could appoint counsel and that we could immediately begin to start refining the issues with a view to presenting them before court in the most truncated form possible, which is a mark of good lawyering. Unfortunately, that has radically changed. As Mary Campbell will tell you, the Correctional Service of Canada's counsel have been repudiated on several occasions by various levels of court for being dishonest, particularly the Supreme Court of Canada, which on 3 occasions to my knowledge has referred to submissions by CSC counsel as, quote, disingenuous. Secondly, I found that provincial authorities similarly have become very, very aggressive in terms of defending their turf, obviously under instructions from their counsel or from their clients, excuse me. There's no doubt, and I've been told this off the record, there is no doubt that Ontario is taking this limited position that Justice Morocco elucidated because they're content to sit back and let a court order them to do so because, frankly, they don't want to spend the money training independent external reviewers. So generally, I find that provincial litigators have become interested in minimizing. I read the ministry's formal response to my report. They want to minimize and wriggle out. And thus, I would be cautious with you about hoping that litigation is particularly going to get you anywhere by being decent. I have come firmly to the conclusion that civil litigation is the way to go. I have a namesake, David Cole, who is the head of litigation for the American Civil Liberties Union, and he wrote a very influential book about 10 years ago, perhaps longer now, looking at the history of litigation to deal with police reform in the in the United States, and he came to the conclusion that the criminal mechanism or the declaratory relief mechanism was not appropriate, because it's only through the hugely broader facilities that come through civil litigation and the rights of discovery that you can get anywhere. And I would commend to anybody the decision of the recent Ontario decision that Kim Pate roughly referred to, of Francis for the lawyers, 2020 ONSC 1644. So that's my talk. We have one question on the list. I'll read it out. Oh, here we go. There's a second question come up. Here's the first one. Notable abolitionist Angela Davis claims that we need to envisage an array of alternatives to the incarceration system, which will require radical transformations of many aspects of society, rather than try to imagine one single alternative. How can policymakers and society more broadly begin to understand, grapple, and ultimately implement this perspective? And I'll just do the second one quickly. Somebody anonymous has just asked me, what were the 3 Supreme Court of Canada judgments where they referred to the CSC submissions as disingenuous? And I'm going to encourage that person to get in touch directly with Mary Campbell, because I'm sure she doesn't have them to mind. But as to the first question, who would like to address that? Kim.
I absolutely agree. In fact, it's a big part of why, when I was approached to consider having my name put forth for the Senate, I agreed. Most of you know I had no intentions, nor would I likely have ever been politically elected or appointed otherwise. And it is the fact that we need to develop the options that provide, ensure that we start with a more equitable situation, because it's the inequities that lead to the use of the criminal and legal system to deal with issues that really shouldn't be there. You've mentioned, David, you were just talking about mental health in particular, and why are people even held on bail? Absolutely. So we should be looking at, and it's part of why I'm working on things like guaranteed livable income, free post-secondary education, mental health care, dental health care, pharmacare. We need to be shoring up the resources that the prison system in the criminal legal system is too often used as a totally inadequate response. And that's how we end up with women, particularly Indigenous women, who are now 44% of the federal prison population, as well as those with mental health issues, as well as those exiting child welfare system or dealing with past trauma of abuse, end up being those, and mostly in the system, and mostly poor people. So the other piece that I think I'd be interested in all of your responses, as well as those in the who are on the session today. Part of the reason that the Senate also recommended judicial oversight was not just because the courts are the be all and end all. I actually agree with David that we can't necessarily rely that the courts will fix this, but it's the only way right now that I can see that we actually force corrections to have to produce the information. Now, they often don't still, but as you said, when those of us who are like Mary or Howard or you or others know that that information exists, it behooves us to let the lawyers know that information exists. And many of you know that's exactly what happened behind the scenes with the Ashley Smith inquest. As a party, I never actually got access to the coroner file, the coroner brief, because I was getting so much information from other sources that we wanted to be able to draft affidavits to show what was actually happening and bring that information forward. So the idea of judicial oversight is really also to expose those inequities and the problems. And I recognize it's not perfect. It's also why I think we need the optional protocol on the Convention Against Torture to be implemented, not just for prisons, but for other institutions like immigration detention and psychiatric detention. But we also need the arbor remedy that the Senate tried to put in, or that did put in, that the government rejected. And that was the ability of prisoners to go back to court, where the way they're treated by correctional authorities amounts to mismanagement of their sentence. So back to the original discussion that I think each of you raised, which is the penalty is supposed to be the separation from community. And if we start implementing those resources in the community, if we start shoring up what has been, you know, the chasms of which have been laid bare during the pandemic. Most of us knew about them before. Somehow, mysteriously, some people didn't know that we didn't have a robust health, education, social services, and economic supports. But if we deal with those, then we end up in the situation I would suggest where Angela and others are urging us to go, which is that we end up with a more equitable situation and less likelihood that people are being criminalized and imprisoned because there's nowhere else. There's no other system that can't refuse them.
Mary, Howard?
Well, I'll just point out, because it hasn't been mentioned, in terms of federal legislation, you know that a completely revised, updated CCRA was done about 1.5 years ago, was done at the request of the correctional investigator, and it is sitting on the shelf at the correctional investigator's office waiting for someone to table it in Parliament. And it addresses many of these same issues because, of course, it followed the drafting of the new Ontario statute and Yukon. So I just want to raise that with people in case you're not aware. A lot of this is right there, ready to go.
Thank you for reminding us, Mary. I've got that. We've called it CCRA. I think they called it 2, and we've called it 2+. We've got some additional amendments that we're looking at in there, so that's great. Yes, stay tuned.
Good.
David, the only thing that I would add, you know, more and more I see my work is just trying to make things hurt, not quite so much. The solutions that we're talking about and how I understand Angela Davis's work are not criminal justice system solutions. And so we can continue to do that. And yes, we can take some comfort that one of the unintended consequences of COVID-19 is that remand populations across Canada have gone way down. But these are not permanent changes, at least not yet. There may be some effort put into trying to take some of these best of these emergency measures and embed them into how we do things and how we think about things. But even that's not going to affect the kind of long-term sustained change that's required. And so those efforts really are largely outside of criminal justice. We can make remand centers the best remand centers possible, and then you could still question why people who shouldn't have ever been sent there are being sent there. That's a much more fundamental question.
Okay, without glorifying the judiciary, I would like to let listeners to this know that there is a program that all 3 of our speakers today have and continue to participate in regularly, that we've put about 400 judges in this country through in the last 25 years. It's a program called Judges to Jails, where both federally and provincially appointed judges get to spend to visit provincial and federal institutions in the Kingston area and are exposed to prisoners both on the street. Rick Sauve is a regular speaker at these meetings, and others, and also to have meetings with prisoner groups inside, where we encourage them to speak very bluntly to the judges. And so I think you can begin to assume that at least some of the judges you are likely to appear in front of, though interestingly, we've never had a single judge from the federal court, that they may in fact already have seen some of the things that go on in these institutions, but it certainly doesn't help to remind them and perhaps to have an affidavit containing some of the pictures, hopefully in color, that Kim and Howard put before us in their presentations today certainly don't hurt. So
Can I just jump in, David, because I think you're far too modest. And if I may say, it was David who really instituted Judges to Jail 25 years ago and has stuck with it and pushed it. And I mean, it's an incredible program. Every judge to a person at the end of the week has said, you know, it changed their life, basically, that they had no idea. And so I think it's, I mean, it's a great program and a great credit to you, David. The federal court did, I think a year or so ago, have a program where they invited me and Lisa Kerr and maybe Howard was there. We probably drove down together in some manner. Howard rents very strange cars. And, you know, I think it was great. I mean, it was one session, but nonetheless, I think they were all, mostly all quite interested in it, maybe more interested in the legalities than some of the lived experience. But nonetheless, they did at least do it once. And that was really thanks to Catherine Kane and Rick Mosley at that time.
I have one question, but it's going to take longer to read the question than to hand it over to Mary to give the answer. The question comes from one Emma Trottier, and Mary, we all know who that is and what that means. So Emma, I'm not going to read your question out because it would take too darn long. And I am going to exercise judge's prerogative and declare this session finished and thank everybody for having participated. Thank you and goodbye and enjoy your afternoon.
Thank you.
Thanks all.
Thank you.
Thank you. Thanks, David.